23XI Racing and Front Row Motorsports have just suffered a major legal setback that threatens to completely reshape their 2025 NASCAR season and possibly their futures. On Thursday, the United States Court of Appeals in Richmond, Virginia, handed down a ruling that could force both teams to compete as open teams without charters, stripping them of guaranteed race entries and significant financial benefits. The implications are massive and far-reaching, potentially disrupting sponsorships, driver contracts, and team operations. This story is unfolding in the courtroom rather than on the track, but its impact could echo loudly through NASCAR's garage and across the sport. To understand the stakes, we have to go back to the core of this dispute, the 2025 Charter Agreement. NASCAR's charter system is essentially a franchise model, giving teams guaranteed entry to every race, a share of prize money, and the ability to sell or lease charters. For years, it's been the backbone of the Cup Series' economic stability, but 23XI Racing and Front Row Motorsports have challenged a key clause in the 2025 agreement that requires teams to waive their right to sue NASCAR for past conduct. The teams argue this release provision is anti-competitive and violates U.S. antitrust laws. Last December, a district court sided partially with 23XI and Front Row by granting a preliminary injunction. This allowed them to compete with full charter status while the legal battle played out, giving them some breathing room and, notably, the chance to buy additional charters from the defunct Stewart-Host racing team. This move expanded their presence on the grid to 3 cars each, a bold step that seemed to signal growth and ambition for both teams heading into 2025. But NASCAR immediately appealed, and the case has been grinding through the appeals process ever since. On May 9th, lawyers for both sides presented their arguments before the U.S. Court of Appeals for the Fourth Circuit. The courtroom in Richmond was packed with tension as attorneys debated whether the release clause in the charter agreement amounted to unlawful, anti-competitive conduct. The appeals court's ruling on Thursday came down firmly in NASCAR's favor, overturning the preliminary injunction. What does this mean? First, the ruling isn't immediate. The teams have 14 days to request an en banc rehearing, where all the judges in the circuit weigh in. But if that motion is denied or not filed, the ruling becomes final on June 26th. From that date forward, 23XI Racing and Front Row Motorsports could lose all 6 of their charters combined and be forced to race as open teams. Without charters, they won't have guaranteed starting spots and must qualify on speed every week. This is a major shift that threatens their financial viability and competitive standing. Team attorney Jeffrey Kessler made the stakes clear during the hearing. He argued that it's not economically feasible for teams like 23XI and Front Row to qualify each week. Sponsors demand stability, drivers want certainty, and the costs of failing to make a race can be crippling. Kessler emphasized that losing charter status mid-season isn't just a business inconvenience. It's a survival crisis that could jeopardize contracts and partnerships. Given the competitive nature of NASCAR and the importance of consistent track time, missing even one event can damage a team's reputation and revenue. Only one Cup race so far in 2025, the Daytona 500, has sent cars home due to field limits. However, being forced into open team status means 23XI and Front Row would constantly face that risk, putting them under enormous pressure every weekend. Beyond that, the financial consequences are enormous. Charters are worth millions of dollars, up to $40 million each in recent years, representing decades of investment in infrastructure, staff, and brand development. Adding complexity, the teams used the previous injunction to purchase additional charters from Stewart-Host Racing, a team that has since downsized to a single-car operation and reportedly won't accept those charters back. The fate of these charters is now in limbo. If NASCAR repossesses them, will they be redistributed or vanish entirely? This raises critical questions about the charter system's stability and fairness. The ruling, in effect, challenges the ability of teams to expand or protect their investments through legal channels. The appeals court's order was thorough and dismissive of the team's antitrust claims. It stated that requiring a release of past legal claims as a condition for doing business does not constitute an antitrust violation under existing case law. The judges found no precedent supporting the argument that such a release is unlawful. Additionally, the court held that 23XI and Front Row had failed to demonstrate a strong likelihood of success on the merits of their case, a necessary standard for maintaining the injunction. This decision is a clear win for NASCAR's legal position and casts serious doubt on the merits of the team's claims as the case heads toward a full trial scheduled for December 2025. Despite this setback, the teams are not backing down. In a statement to media outlets, including Fox Sports' Bob Pokrass, their attorney Jeffrey Kessler expressed disappointment but affirmed confidence in their ultimate victory. Kessler characterized the ruling as narrowly focused and stated the teams remain committed to racing and pursuing a fair economic system free from monopolistic conduct. Financially, the implications are staggering. Losing charter status means losing guaranteed prize money and revenue streams critical for operational stability. These funds pay for employees, technology, travel, and day-to-day expenses. Without them, 23XI and Front Row could face severe budget shortfalls, putting sponsorship deals and driver contracts at risk. Sponsors typically seek assurances that their teams will compete in every race. Losing charters mid-season injects uncertainty, potentially triggering contract clauses or withdrawal of support. The ripple effects extend beyond these two teams. 23XI Racing, co-owned by NBA legend Michael Jordan and NASCAR star Denny Hamlin, has become one of the sport's most recognizable and exciting brands. They've drawn new fans to NASCAR and helped modernize its image. Losing such a high-profile team would be a blow to the sport's growth and visibility. Front Row Motorsports, on the other hand, is a respected underdog success story with race wins and a reputation for punching above its weight. Their potential loss would remove a beloved competitor from the field. The ruling also raises existential questions for NASCAR's charter system. If charter status can be revoked this easily, what protections remain for other teams? Will NASCAR's system evolve or become more unstable? Could other teams challenge their agreements and unsettle the field? The answer to these questions could redefine how NASCAR operates and how teams invest in their futures. On the legal side, the court emphasized that the mandatory injunction was improperly granted because it required NASCAR to do business in a way it claimed was unlawful. This highlights the court's reluctance to interfere with NASCAR's business model without clearer legal grounds. The heightened standard for issuing a mandatory preliminary injunction means courts will be more cautious about forcing NASCAR to change its agreements mid-season. Meanwhile, the battle over the Stewart-Haas charters remains unresolved. Since Stewart-Haas Racing has no use for the two additional charters and reportedly won't accept them back, NASCAR may have to decide whether to repossess and reassign those charters or let them disappear from circulation. This could affect the total number of chartered teams in the field, potentially shrinking the guaranteed spots available. Looking ahead, the real trial begins in December 2025. This will be a landmark case with implications not just for 23XI and Front Row, but for the entire NASCAR ecosystem. Fans, sponsors, and teams alike will be watching closely. The fight is about more than legal technicalities. It's about the economic and competitive future of stock car racing. So, what happens next? Will 23XI Racing and Front Row Motorsports request a rehearing and potentially reverse this ruling? Or will they face the harsh reality of open team status for the 2025 season? Can they maintain sponsorship and driver loyalty without the safety net of charters? And what will NASCAR do to manage the fallout, both financially and competitively? This case is a watershed moment in NASCAR history. It challenges the stability of a system designed to protect teams and ensure competitive balance. It forces the sport to confront tough questions about ownership rights, legal protections, and economic fairness. What do you think? Should NASCAR defend the charter system at all costs to preserve stability? Or is it time for reform that might open up the sport but introduce more risk and uncertainty? Will 23XI and Front Row survive this legal storm and continue to grow? Or is this the beginning of a tough new era for these teams? Drop your thoughts in the comments below. Don't forget to like and subscribe for all the latest updates as this complex legal saga continues to unfold. This story isn't just about lawsuits, it's about racing, ownership, and the future soul of NASCAR.